Hi, I'm Danielle Lackey, General Counsel at Modus. In the first half of this segment, we talked about the growing mobile workforce and how this creates opportunity for cost savings in your business mileage reimbursement programs. Now I'm going to talk about legal risk for failing to do that. In terms of mitigating risk, there are federal and state labor laws that come into play for business mileage reimbursement. On a federal level, there's the Fair Labor Standards Act. This is the law that requires your employees be paid at least the federal minimum wage. Though mileage reimbursement is not mandated by the FLSA, under reimbursement can still result in a violation. Why is this? So an employee must earn the minimum wage after any business-related expenses are paid by the employee. If you have an employee who's driving their vehicle for work and the cost of operating that vehicle is more than they're being reimbursed, when you net those numbers out, it can drop you below the federal minimum wage and open you up to litigation and Labor Department penalties. And the risks and consequences are real. There have been class action lawsuits around the country on this issue: California, Ohio, Minnesota, and others, and some big brand names that have had to pay out in settlement of these claims. Because the FLSA requires employers to reasonably approximate the amount of an employee's expenses, it's important to have a defensible and technology-driven system in place for how you make this approximation. Moving to the state requirements, take for example California Labor Code Section 2802. Under this law, employers must compensate their employees for any expenses associated with performing their job duties or following the directions of the employer. This includes mileage reimbursement for employees who are required to drive for their jobs. To bring a violation under 2802, an employee just has to show three things: that they're an employee, that they incurred a necessary expense, and that their employer failed to reimburse them. It sounds simple, but it can come up in some complex ways, and I'll walk you through a couple examples. Starbucks employees sued the company, claiming that they were never reimbursed for the expenses accrued when using their vehicles to do their jobs. In this case, it was true. Starbucks was not reimbursing their employees for driving, and they paid out $3 million to about 30,000 employees. But what's interesting about this case is that these employees were not driving very far, so they're not what you would think of as drivers in terms of your employees. The court even acknowledged that the activities that took place were all pretty close to the work site. These were managers. They were people who were driving to make bank deposits, purchase supplies, and attending meetings. But nevertheless, 2802 applied and the company had to pay out. In another case, HARTE Hanks Shoppers was sued by their employees under California 2802. And here the company was paying their employees for their expenses. What they were doing was paying a flat allowance, so they were adding to the salary to compensate for vehicle expenses. The problem here is that the company wasn't delineating in their paychecks what was what. So employees claimed that they couldn't tell when they looked at their payment what was salary and what was reimbursement. So even though the company was reimbursing, the court ruled that a method must be in place to identify what represents the reimbursement, and HARTE Hanks paid out $7 million to settle the case. There are a few interesting things about this case to note. First of all, the court also said that payment of the IRS rate, so that 54 cents per mile, does not create an indisputable presumption of 2802 compliance. So an employee can come to the employer and show that their expenses were higher than that number and be reimbursed. The court also noted that employers are only responsible for reimbursing their employees for the expenses necessary to do their job. So an example for this is, let's say your employee is delivering pizza and they choose to own a new Suburban. You, the employer, don't have to reimburse for the cost of driving a new Suburban, but you do need data that explains why you're reimbursing what you're reimbursing. So if your position is that the car necessary to do the job is a mid-sized sedan, and you have data to substantiate that, you're on solid footing for 2802. So I've been focusing on the California provision. There are a number of states that have followed suit in instituting similar language in their legal codes. Montana, Massachusetts, the Dakotas, New Hampshire all have laws that touch on some of these issues. To close, mileage reimbursement is a big line item, and it's an area of huge potential and huge exposure. Using technology to accurately track this number is critical to IRS compliance, accurate corporate accounting, hard cost savings, and mitigating litigation risk. What we didn't touch on is that in addition to accurately tracking, it can help inform business decisions around managing your field level folks and streamlining their activities, and gives you the business intelligence to be able to do that. All of this can be done within a system that saves you money. Thanks for watching, and if you have any questions about anything we've covered today, please feel free to reach out to Modus.